Thank you very much, Eric. Our next speaker is an attorney and former prosecutor and expert witness who has devoted his career entirely to firearms and self-defense law. In 2006, he co-founded Legal Heat and led its growth to from a single location to more than 240 monthly training sites across 46 states. Today, he serves as the Senior Vice President at U.S. Law Shield, which has supported over 2 million members in their self-defense journey. Let's welcome Philip Nelsen.
All right, everyone. Thank you. Appreciate you allowing me to be here. I want to thank, Adam and Alan and Lauren and the Second Amendment Foundation crew. I do a lot of these conferences, go to a lot of these conferences, and there are very few I've ever seen that have the lineup of speakers and the group that's here today. Being in this industry for about 20 years now, you realize that it's a big industry. The firearm industry is large and it's small at the same time. There are a small, cohesive group of people and organizations that help keep this industry running. And so I'm privileged to be here. I appreciate the opportunity. Now, I'm going to talk to you today about an interesting subject, and it's lessons learned from self-defense trials. And Charlie mentioned I worked as a prosecutor for a while. I've been a defense attorney for a lot longer than that. And I also work as an expert witness in use of force cases. So I've had the kind of unique perspective of sitting at 3 different places in the courtroom during these trials. But more than that, I'm kind of here representing a group of attorneys at U.S. Law Shield, 400 of them, that litigate these cases daily. So U.S. Law Shield is an organization that provides self-defense insurance. When you're involved in a use of force case, you'll pick up your cell phone, you'll call a 1-800 number, and the attorney in your state answers that phone directly. And we get, just to give you an idea, we get about 10 to 12 of those emergency calls a day across the country, which will eventually end up being life-altering circumstances for our clients. So I want to share with you some of the lessons that I've personally learned, but also that our attorney network has learned. And so I mentioned, by the way, I'm a Utah attorney. I want to welcome you to Utah. Utah is a fantastic state. I hear some people on the breaks grumbling about where you live. Come on out. Utah's great. It's a great place for the Second Amendment industry. It's a great place for the Second Amendment rights. So we'd love to have you. Okay, so let's talk about some lessons learned from self-defense trials. And time's pretty limited. I'm going to try and get 3 primary lessons across that we've learned in doing these hundreds and hundreds of trials. And the first thing that I want to get across is that most self-defense cases, so most trials, end in a guilty plea by the defendant. And that is, and I don't know why the actual icons aren't showing up there, so I apologize. But 73% of times when you go to trial are going to result in a guilty plea by a defendant. And I shouldn't say go to trial. The cases resolve in a guilty plea before trial. Now, why? Why would somebody plead guilty without taking their their case to trial? Why would they do that? Well, the reason they do that is a few reasons. First of all, the jury trial outcomes. What percentage of cases end up being a guilty verdict? And I bet this will surprise you. Amongst felony cases, you have 66 or 68, I'm sorry, my eyes are bad, 68% of cases end up in a guilty verdict. And amongst misdemeanors, 77. If you work your way down, acquittals, you only get 27% on the felony cases and only 19 on the misdemeanors. And then 4% dismissal or 3%, and then other 1%, which will be a mistrial or something like that. And so what the lesson we learn from this is, at trial, the odds are stacked against a defendant. So the first reason that people don't take their case to trial is because statistically, the odds are stacked against them, and that's not a good thing. So the first lesson that I want to convey is that by the time you get to trial, you've lost several significant battles. Getting to trial is a loss. You shouldn't be going to trial in a self-defense case. If you end up at trial, you've already lost several times along the way, and I'm going to illustrate why. The second thing, the reason that people don't go to trial, is the cost. The average cost of a self-defense murder trial, so we're talking first degree, second degree, or manslaughter case. The cost of that is staggering. Now, we have our own costs internally, but I kind of wanted to use an outside source so that you can rely on this. This is a University of Nevada study that they evaluated the cost of these cases. And just to give you an idea on the time that is spent on each of these. So, and again, my bad eyes are going to do me a disservice here. But before you get to trial, the pre-trial phase, you are thousands of hours of legal work into a case before you get in front of a judge and jury. And that involves obviously the expert witness preparation, the crime scene investigation, the attorney, and you'll usually have at least two attorneys involved in this. So you'll have a first chair and a second chair attorney. They're all preparing their briefs, their discovery motions, and a lot of the battle that goes into a trial happens before it actually goes to trial. Then the actual trial phase, still significant, hundreds of hours. And then if you get convicted, the post-conviction phase, you have another couple hundred hours. And the total for all of those ends up being over 2,000 hours for a capital case, which is a first-degree murder case, or nearly 2,000 hours for a non-capital case. Now, what does that mean in terms of money? Well, Clio, which is a legal research organization, Clio says the average criminal defense attorney charges $211 an hour. So if you hired the average, now, does anybody want an average attorney defending yourself? No, of course not, right? So the average, we're talking kind of run of the mill, you just pick up you Google criminal defense attorney in your town, you call. And so what that ends up meaning is it's $480,000 approximately for a capital case for an average attorney, or $230,000 for a non-capital case. Now, the average median family savings in America. You have a guess of what the average family in America has in their savings account? It's $8,000. All right, so what does this teach us? Well, the first lesson is, again, if you get to trial, you've already lost significantly because the average American cannot afford to pay $200,000 to $480,000 for a quality legal defense team. And that, again, that's average. We just finished a case in Denver where our attorney, we call them independent program attorneys or IPAs, our attorney billed $770,000 for that case and won. But I mean, you got to understand what goes into those cases. We fly in actors that are the same size, weight, height as the defendant in the case. We recreate it all through CGI. Because we need to show a jury what it looked like on that day and place them in the position of our defendant. And that is a very difficult thing to do. So the first lesson we learn is that the average American cannot afford a quality legal defense. The second lesson I want to teach is that self-defense cases are won often in the legislature. And so the reason this is important is we've got a lot of people that have spoken here over the last couple of days that are involved in legislative efforts. And there is a lot that can be done in the legislature to win a self-defense case at trial. And I want to illustrate three examples of that. The first is what's called a stand your, or a presumption of reasonableness or stand your ground statute. So first talking about stand your ground. So stand your ground laws, by the way, shout out to Utah, were invented in the state of Utah. Now, when you think of stand your ground, you probably think of two states. What states do you think of? Florida, right? We had the George Zimmerman case, which, by the way, stand your ground was not used in that case. That was not a legal defense in that case, but it got a lot of publicity. And you might think of Texas, right? But Utah actually invented stand your ground laws. And back in 1994, we passed a statute. And the way that statute reads is a person does not have a duty to retreat from the force or the threatened force in a place where the person has lawfully entered or remained. And so what this does is it shifts the burden at trial away from the victim being the defendant in a case. No longer does the assaulted woman have to prove to a judge and jury that they tried to run away before they shot the assailant. That no longer has to happen in a stand your ground state. And so each of these are massive wins for a criminal defense attorney that has to stand up and argue, because you have to prove that your client avoided all legally obligated or exercised all legally obligated means to avoid using deadly force. And this, if you have to prove this, is a very difficult one to prove. So if you're in a duty to retreat state, then you have to prove that your client could not have retreated. An example of this, I'll give you an example of Nebraska. Anybody from Nebraska in the room? All right, hey, I see you got the Nebraska hat on too. You got some work to do. So Nebraska not only has a duty to retreat, Nebraska has a duty to surrender an item that an assailant is requesting before your use of deadly force. You have to demonstrate at trial that not only did you use all reasonable attempts to retreat, but also that you gave them what they were asking for before you shot them. Because if you didn't, then that can be used against you. You have a burden to prove that. That's a crazy standard, right? And so we have seen a growth of these stand your ground laws. In fact, I've got the statistics here. Since the year 2000, so in the last 25 years, there are currently 38 states that have stand your ground laws. By the way, the difference in the colors on the screen, the light blue are common law states, which means the courts have ruled that there's no duty to retreat. The dark blue are legislatively enacted, which means that they've passed laws. We prefer the statutory states, the ones where the laws have been enacted by the legislature. But to give you an idea, of the 38 that are there, and especially of the legislative states, of the 30 that are there, 26 of those have enacted those laws in the last 25 years. So these are modern things that we're doing to help defend people at trial. Now, because I just finished, just before me, a Florida resident gave their presentation. We've got several Florida residents here. I'm going to talk about Florida. So back prior to 2005, the standard in Florida at trial was, in order to justify the taking of human life, the accused must have used all reasonable means within his power and consistent with his own safety to avoid the danger and avert the necessity of taking a human life. Again, that was the standard you had to prove. So what it opened the door for was a prosecutor to show a security camera footage and say, oh, why didn't you run out the door behind you before you shot the person? Now, of course, in that use of force situation, as the defendant, you're saying, I didn't see the door. I saw the threat. But later, a jury is able to look at that and say, oh, well, yeah, the door was right there. And so when they go back in and they deliberate in their jury in the room, they're saying that kind of stuff. I would have just ran out the door. Well, it's because that jury member's never been involved in a use of force encounter and doesn't realize the tunnel vision aspect and what happens physiologically to the victim in a situation like that. So thankfully, Florida changed their laws. And after October 1st, 2005, they changed it so that they had a stand your ground statute. I want to talk about kind of what that did, and I've only got a couple minutes to do so. So after they did that, they established what's called a pretrial immunity procedure. And what that allows is basically for a defendant to petition a court for, before they go to trial, to have an immunity hearing. And these are big, and several states have started doing this. Utah is trying to get one passed right now. Carrie Ann Lisenby, who was here yesterday, is authoring that legislation, and Clark Aposian, who's here as well, is trying to push it through. The pretrial immunity, yes, I know Carrie Ann's still working on some tweaks to that. It's a great piece of legislation. In 2017, they shifted the burden. And so now what it says is, once the defendant makes a prima facie claim for self-defense immunity, the burden of proof by clear and convincing evidence is on the party seeking to overcome the immunity. Translated, it's not innocent until proven guilty. It's really innocent until proven really guilty is the standard. And that's the standard we want in self-defense cases, because again, we're putting the victim on trial here, and victims deserve better rights. Okay, what the results of this were is, after this happened, 67% of the time when somebody raises a stand your ground defense in Florida, they are found not guilty. They win that case. And of those cases, 79% of them would have previously involved an argument by the prosecutor that there was a duty to retreat. And so 79% of those cases could have looked very different had that law not been changed. And then I'm going to skip through a few slides. The second one is a presumption of reasonableness standard. Now, this is one we've still got a lot of ground to make up. Presumption of reasonableness laws, which are the dark blue states on that map, that starts with a presupposition that when somebody uses deadly force in specific circumstances, like within their home, they are presumed to have reasonably perceived a threat of imminent bodily injury or death. Meaning, the default is they were justified until the prosecution's able to overcome that. The burden isn't on the defendant to prove they were reasonably in fear of serious bodily injury or death. It starts with that presupposition, and now the defense has to overcome that. And that is a big, big win for a defense attorney at trial. And this is what one of those statutes looked like. This is Utah's, which we have that here. And so it is a big win for states that have those. If you're in one of those light tan states, you've got some work to do with your legislature to get that done. And again, the second lesson I want to pass on to you is that a lot of these self-defense trials are won in the legislature. Arguing a case in Nebraska is significantly different than arguing it in Utah or Florida. And so those legislative initiatives can help. And finally, the last thing that I want to share with you, which I don't have time to go over, is do you know who the biggest threat in a self-defense case is besides the person that was shot? So other than the attacker, the biggest threat to you is you. It's you. It's the stuff you say when you call 911. It's the stuff you say when the police show up. Now, you'll have a lot of instructors out there that'll say, okay, don't give a statement. Here's the reality. You will give a statement. You're going to. I've never worked on a case where the defendant didn't give a statement. In that instant, your brain switches and you're going to give a statement. So you need to work with, preparing what that statement would be and requesting your attorney. And we recommend giving an immediate public safety statement of, here's where my injuries are, here's where the attacker is, here's where the weapon is. I'd like to speak with my attorney. And that's in alignment with what law enforcement groups will recommend as well for their decompression period. All right, I have ran out of time. There is a lot more information I would cover, but I want to thank you for all you're doing for the Second Amendment. It was a pleasure speaking to you today.